Hello, it's Philip Taylor speaking from Richmond Green Chambers. This morning I'm looking at a book from Oxford University Press, OUP. We do a lot of reviews for OUP over the years, and this is a particularly interesting book in view of where we are at the moment in our relationship with the European Court of Justice, with the issue of Europe being top of the agenda, both for the public and for the political gentlemen and women at Westminster. We've got a book which has come in, which I think is really excellent. It's a new second edition now of preliminary references to the European Court of Justice, and it's been written by Morten Broberg and Niels Fenger, and I hope I pronounced their names correctly. This is the book here. It's very much what you would expect from OUP. It runs to just under around about 500 pages. Got a very useful, detailed index at the back. What you've got as usual, of course, is you've got quite detailed footnotes. You can see those there. You've got a lot of very heavy information, rather more detailed footnotes in fact there. And then you've got a series of chapter headings, and let me just give you one example here. This is the preliminary ruling, judgment or order. So what they've done is they've gone through this very logically to try to work out exactly what you want. There's the front bit of it. And there's also a preface which I suggest you do read if you're going to make any preliminary references. Then you've got the contents which you can see there, and then there is in fact a very useful bibliography at the back, because there's always a lot of additional reading and links which you may be wanting to look at. The bibliography is in fact books. What you have got as well is much more detail in terms of the contents, depending on what you're looking for and the type of references you want to make. Then table of cases, of course, there, which is quite substantial. And then you get, again, very important list of abbreviations, something that I always find very helpful. Then we start straight in. You've got paragraph numbering at the side there, which makes it quite easy to find, and it starts off with references for preliminary rulings and how we go about it. Now, we've written a review which is on the web, and it's in the journals, and we gave it the title Thorough and Concise Advice to Practitioners on Submitting Preliminary References to the European Court of Justice, the ECJ. Been written by myself and my wife Elizabeth, who is my systems administrator. We start off with a quote. Preliminary references are a mechanism created to ensure the homogenous application of European Union law throughout the member states, explain the authors of this scholarly and rigorously detailed work of reference, which should certainly clarify any issues that you may have pertaining to the working of the ECJ. Now, it's been published by OUP and it's now in its second edition. And it's become, I think, a text which is of vital interest to practitioners involved with disputes scheduled to be held before the ECJ. The problem being that a lot of people have got very sketchy knowledge, to a certain extent, myself included, and I did the European module for the bar exams, but I still find it quite daunting to work out how one is actually going to deal with making these preliminary references, but because they're basically they're applications. It was originally published in 2008, this book, in Danish, and it's been translated into 3 other European languages, plus of course English. The new English version therefore makes a timely appearance following the enactment of the Lisbon Treaty after 2009. And it's important to note that the preliminary reference to which the title refers inevitably precedes the preliminary ruling by the ECJ. The book is therefore especially useful, I think, for practitioners in that it deals with the amended procedures post-Lisbon which are involved in making a preliminary reference, which inevitably involves written advocacy, the one element which will make or break a case, as we found out with judicial review in the UK. And I think we have to recognise effective written advocacy is very much the way we are moving at the moment. There's not anything like as much standing up and spouting, if you like. It's much more writing everything down so that people can assess it and read it. And when you're dealing with a multiplicity of languages, of course, that in itself does lend to a lot more assistance if you've actually got the written word to look at. This new edition contains much new material, including, for example, a completely rewritten and expanded section on the doctrine of acte claire, which is examined in length, and which provides yet more evidence of continuing attempts to achieve further harmonisation of legal processes across the EU. Now, whatever your views, that must be a good thing, so that we get some form of standardisation, but let's be very clear about it, it's going to take a long time. Some will argue, of course, that such harmonisation is but a distant dream, and as the authors have done, will point out that the EU has expanded to, by 2013, 28 member states and 24 official languages. But you've got to make a start somewhere. I'm pro-European, although I have my own questions to raise about it, but you can see that the general aim is to try to standardise. And our view, certainly at the English bar, is that the common law is one of the greatest things that we actually have. That's why people come to London to deal with their legal issues. So therefore, we've got a great deal to offer. And I think if we take that stance, it's far better perhaps than some of the other approaches that may be adopted. But that's for another issue. Our comment, and it's an obvious one, is that the level of linguistic and cultural diversity that we now have in the EU will have any number of implications and consequences which the court must address in arriving at judgments which are seen to be fair to all parties embroiled in a dispute. For example, will it be necessary to check each of the official language versions of each applicable EU provision to ensure that each version means the same thing? Well, not really, or not exactly, because you're going to start having difficulties in interpretation very quickly. As the learned authors have explained, the European Court of Justice has merely reminded the national courts of the multilingual character of EU law, and has thus drawn the attention of each nation court to the fact that, quote, even where the interpretation of the specific EU Act may appear to be straightforward, the interpretation of the same Act may turn out to be much more complex when other language versions are taken into account. And that obviously follows from as common sense from what is happening. Practitioners, therefore, involved in the complexities of this area law will, we think, certainly appreciate the book as a guide. That's really where I came in when I looked at it. So it's a guide, so to speak, as to what to do and what not to do when structuring a preliminary reference, and the reference being, as I said earlier, in fact, an application of sorts, as we would call them in the United Kingdom. And I'd draw attention to certain chapters which practitioners will find particularly helpful. Chapter 8 focuses on the form and content of a reference. Chapter 9 deals with the proceedings before the referring court after a reference has been made, and Chapter 10 deals with the procedure before the Court of Justice, and the final chapter provides succinct and useful guidance on litigation costs and legal aid, although it's rather short on that area, I hasten to add. As an advice book for advisors, then, this volume of over 500 pages, about that, functions also as an invaluable research resource. It's copiously footnoted throughout, as I've shown you, and it contains almost 80 pages of tables of cases and of legislation, including treaties, conventions and directives. Plus, of course, that handy list of abbreviations, which I find I refer to more than I would probably think. The detailed table of contents and comprehensive index aid navigation as well. So let me conclude by saying that as an up-to-date guide to what you as a practitioner have to do to make your application to the court before you even set foot in it, this book, we think, will doubtless emerge as an indispensable addition to your professional library, and the publication date is 2014, and I'm reviewing this in the middle of 2014. Let me just show you chapters 8, 9 and 10, because they are quite important. Chapter 8 deals with the form and content of a reference, and that's what it looks like there. That's really where your starting off point is. And it's quite a long chapter. Then you've got the proceedings, which are actually set out. There's proceedings before the referring court, after a reference has been made. And then chapter 10 is the procedure itself before the ECJ, and that again, there's quite a lot of case law and various other things, but that is extremely helpful. I'd like to thank the two authors, Broberg and Fenger, very much indeed for this, and to all the people at OUP. We value these books. They are of a very high quality, and they make, to a certain extent, the law and the task that we have so much easier. So thank you to all concerned. Goodbye.